so we're unmuted now. Okay.
Okay.
Oh,
Okay. Ma'am, can you see me and hear me?
Yes.
All right. Can you please state and spell your name for the record, please?
Sure. My name is Gladys Blair, GLA.
Here we go, folks. Before this hearing even kicks off, let me set the stage, because this case is one of those situations where you feel your stomach drop. Before the first question is even asked, we have a mother taking the stand to describe what happened to her daughter after a night that no one should ever have to live through. This isn't just another domestic violence case. This is a case involving brutal injuries, emotional trauma, and a judge who is clearly fed up with what he sees as a pattern of manipulation and threats. As you watch, pay attention to the small details. Watch how the witness speaks, how the attorneys navigate these questions, and especially how the judge reacts later. This case takes a sharp turn from a standard preliminary exam into something much darker, filled with accusations of strangulation, threats against children, and even animal cruelty. And trust me, when the judge delivers his analysis at the end, you're going to understand exactly why his emotions spike the way they do. So buckle up. This one moves fast, hits hard, and raises a lot of questions about intent, credibility, and the fine line between threats and attempts. I want you to really think about the evidence as it comes out. What would you have done? What signs would you notice? And as always, stick around until the end, because the judge has a moment that completely changes the tone of this case. Let's get into it.
ADYS, Blair, BLAIR.
All right. And if you could please raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Thank you. Ms. Tanner, you may go ahead.
Thank you. And Ms. Blair, if you can't hear me, please let me know. Can you hear me okay right now?
Yes.
Okay, thank you. Ms. Blair, I'm going to be asking you some questions, and then when I'm done with my questions, defense counsel might have some questions for you, okay?
That's fine.
I want our camera locked on.
Right from the start, you can feel the formality set in. As the judge confirms audio and visual, it may seem like a small detail, but this is crucial in virtual hearings. If a witness can't see or hear properly, their testimony becomes vulnerable to challenge later. Defense attorneys love to jump on any technical misstep, so this simple check helps lock the record down. More importantly, this moment sets the tone for Miss Blair's role. She is not here for guesswork. She is here to give firsthand observation of her daughter's condition, which becomes a major pillar of this case.
On the podium, so she's got something so that she's safe, Miss Tanner. Got it? Okay, go ahead.
Thank you. If at any point you are not hearing me or confused about something I'm saying, feel free to let me know. I'll try to speak up. I'll try to clarify, okay?
Sure. Thank you.
Okay. Thank you. Miss Blair, do you know someone named Candace Ori?
Yes.
Now this is where prosecutors start building their foundation. Notice how calm and methodical the questions are. They're not diving into the drama yet. They want to establish identity, relationship, and basic context before opening the door to anything graphic. That's intentional. The cleaner the foundation, the harder it is for the defense to shake it later. Miss Blair also comes off polite and cooperative, which helps her credibility tremendously. Jurors especially notice tone. When a witness seems straightforward and willing to answer, their testimony hits harder. Keep watching how she handles the tougher questions coming up.
Yes.
And who is that to you?
That is my daughter.
And are you familiar with someone named Dwayne Stevenson?
Yes.
Okay. And how are you familiar with Mr. Stevenson?
Through my daughter letting me know that was her boyfriend at the time.
Okay, thank you. And sometime in July, did your daughter come to your home? And without going into, I'm not asking what she said to you at this point, okay? But did she come to your home and say something to you that leads to you being here today?
Yes.
Okay. Again, I'm not going to get into what she said at this point, okay?
Okay.
If you could please describe.
Here's a good moment to point out how respectful the prosecutor is being. She warns the witness multiple times not to share statements or hearsay yet. This shows the court that she's following procedure and not trying to sneak in prejudicial information. These trials are like chess matches. Every move is calculated to avoid giving the defense any opening for objection. Also notice Miss Blair's soft-spoken nature. It highlights just how heavy the subject matter is. When someone sounds this gentle and still describes what you'll hear next, it makes the impact even stronger.
Please describe to the court just what you saw when you went to open the door and it was your daughter. Could you tell the court what you saw?
I saw my daughter's left side of her face swollen, her lip busted, some teeth missing, one dangling. Very hard for her to walk in the house without assistance. And you can tell that she was in pain all over. It took her some time to walk to me. And she just kept saying, "I'm sorry, I'm sorry, I'm sorry."
I'm going to ask you some more questions about that, Ms. Blair. Before I do, if you get to a point where you need to take a break, please let us know, okay?
Okay.
Are you okay to keep going?
Yes.
Okay.
This is the moment where the whole energy shifts. The prosecutor asks her to describe what she saw, not what she heard. That's a critical legal distinction. Visual observations are admissible. Statements from others, not always. And when she mentions the swollen face, the busted lip, the missing teeth, you can practically feel the gasps from anyone watching this live. Injuries tell a story long before words do. For many judges, physical evidence is often more convincing than emotional statements because it's harder to dispute. So ask yourself, if you opened a door and saw your child like that, what would you think?
What was going through your head when you saw your daughter in that condition?
A whole lot of hurt, anger, frustration. I wanted to hug my daughter and never let her go. And I wanted the pain to stop.
Was she by herself or was someone with her?
Someone was with her, my grandson.
Is that Jace?
Yes.
Again, without going into anything that was said at this point, what happened next? So you open the door, she comes in. What happened next?
My other daughter, April, saw her as well. And she was very upset as well.
Your Honor, I'm going to object. That wasn't, first of all, it's not the question she was asked. And second of all, what somebody else was, she can't testify to.
When Miss Blair says her daughter kept repeating, "I'm sorry," that speaks volumes. Victims often apologize because they've been conditioned to believe they're at fault. This is a hallmark pattern in long-term abuse cases. It also reinforces the prosecution's theory that the victim was operating under fear and emotional control. Judges take this very seriously. It suggests not just physical violence, but psychological manipulation. Notice, too, how the prosecutor checks on the witness's emotional state. That's not just compassion, it's strategy. A calm, steady witness makes the testimony more powerful and less likely to be seen as exaggerated.
That's okay.
I'll sustain the objection.
I can, if I may direct the witness a little bit, that might help. Thank you. What did your daughter, Candace, do after she came into your home?
We went down the hallway and we went into my room.
Okay. And what happened when you got to your room?
I helped the sister to sit down on my bed.
So I didn't understand that.
I helped assist her to sit down on my bed.
Was she able to do so without trouble? If you know, only if you know personally. I don't want you to guess or based on anything anyone told you. Did your daughter go to the hospital?
Yes.
What was your daughter's demeanor? And by that, I mean, what was her tone, body language like?
Here we see the first major objection from the defense. They jump in immediately when Miss Blair mentions another daughter's reaction, and their right to do so. A witness can only testify to what they personally observed or experienced. They cannot speak for another person's feelings or thoughts. The judge sustains it without hesitation. What's interesting is how calmly Miss Blair regroups. Many witnesses get rattled after an objection, but she stays steady. That kind of composure helps preserve her credibility. Let me ask you, do you think the defense is picking at small details or doing their job properly here?
Like, did you notice any emotions from her?
Yes.
Could you tell the court about that, please?
She was very upset in tears. She was shaking very badly. She just kept saying, "I'm sorry." And she kept saying, "Why did this happen?" She kept saying, "I should have said things and I didn't know how to say things." And after that, she just kind of went into a ball of tears. And she said she just wanted to go to the hospital to find out, was everything okay? Because she didn't feel okay.
Thank you.
Once again, watch how carefully. The prosecutor redirects the testimony. She guides the witness back to her own observations and away from anything invalid. Then she confirms whether Candace was able to move, walk, or sit without difficulty. These questions are not random. They build the case for GBH, great bodily harm. If a person can't walk or sit without assistance, that suggests internal injuries, possible concussion, or severe pain. This step-by-step process helps the judge understand the severity without relying on medical jargon. It's simple, clear, and effective.
May I have a moment, Your Honor?
You may.
Thank you. No further questions at this point, Ms. Blair. Thank you.
All right, Mr. Goldstein.
Ms. Blair,
Yes.
Ms. Tana prefaced her questions by, or maybe you did, I'm sorry, said something about July. Do you know what date it was that she came to your house?
4th of July weekend.
Okay. And it was not in August, it was not August the 12th then?
No.
Okay. And do you know if the police were called on the day that she came to your house?
Excuse me, say that again, sir?
Do you know if the police were called the day that she came to your house?
Yes.
Okay. And do you know which police agency?
I called my police agency.
Yeah, I'm going to ask you a question. Don't give me your exact address, but what city do you live in?
Detroit.
What city? Detroit? And what
Yes.
city did your daughter live in?
Ypsilanti.
Okay. But you made the call, is that correct?
Correct.
And you called the Detroit police?
I called the police, and that's who answered where I lived.
Detroit.
Yes.
Okay. Was any contact made either by you or in your presence with the Ypsilanti Police Department?
Not at that time.
Okay. And when you say she went to the hospital, do you know how she got there?
EMS.
And do you know which hospital?
Yes.
Which hospital?
Sinai Grace.
Sinai Grace?
Yes.
And that's, if I remember correctly, that's in Detroit, right?
Yes.
Okay. Not Trinity Health, not St. Joe.
No.
Okay. Only time that, I'm sorry, When you observed her,
This scene is heartbreaking because it reveals the emotional aftermath, not just the physical damage, shaking, crying, apologizing, questioning herself. These are classic signs of trauma. When victims begin apologizing, it often means they've been manipulated into believing they're to blame for their own pain. The defense cannot easily undermine this type of testimony because it comes directly from a mother describing what she saw. Judges pay close attention to emotional demeanor because it often aligns with authentic trauma, not fabrication. Let me ask you, if you were the judge listening to this, would you doubt her?
you said that she had some physical injuries that you could see,
Yes,
and one of them had to do with her teeth.
yes.
Okay. Nothing further, Your Honor.
All right. Any redirect?
Nothing further, Your Honor.
Nothing further? Okay. Ms. Blair, thank you very much for your testimony, ma'am. We do appreciate it.
Thank you.
Thank you. All right. You call your next witness if you need.
Your Honor, you have no further witnesses at this point.
All right. Further witnesses for the defense? None? All right. Do I have a motion?
A few things, Your Honor. I'm going to request the court add a few different counts based on.
I assume that.
Your Honor, let's start with me. The first one would be an assault with intent to murder. That's under 75083. And I believe that would be
750.83.
0.83. That's a life offense. Should be added count. This point 7, Your Honor.
Yes.
We would also motion to add counts 8 and 9. Assault with dangerous weapon. It's a 4-year felony and or $2,000 fine. It's under 75082. And that's for counts 8 and 9.
That's felonious assault.
Felonious assault, correct, Your Honor.
Yes. All right.
We also motion to add, Your Honor, animal cruelty. That'd be added count 10. Under 750.5048. Subsection 1, subsection B specifically. That's a 93-day misdemeanor and or $1,000 fine with up to 200.
The defense now gets their turn, and their strategy is clear. Narrow down the timeline, question the police jurisdiction, and highlight any inconsistencies. They're trying to establish doubt about when and where these events happened, but Miss Blair stays consistent. She says it was the 4th of July weekend, not August. She confirms she called Detroit police, not another agency. This consistency helps her credibility. Notice how the defense avoids emotion-driven topics. They focus strictly on logistics. In cases like this, defense lawyers often try to chip away at the structure instead of the story.
200 hours of community service. Your Honor, I would motion to add an added count 11. Malicious destruction of personal property. That's a 1-year misdemeanor and or $2,000 fine, or 3 times the amount.
That was 750.
Was 750-377-A1C1.
Okay.
I would motion to amend the complaint. Again, so I know we initially had motion to amend from June 1st to July 30th. I would motion to extend that to August 15th of 2025.
Yeah, I thought that was already done. I thought you already did.
Well, not till August 15th.
Yeah, no, I know, but I thought when she started testifying about August.
I mentioned it. We didn't actually.
Okay.
Didn't actually
We'll
do
make
it.
sure we get it all.
Okay.
Your Honor, I believe that should be it. Oh. And Your Honor, I'd ask for bind over on the felonies included the added counts as well as having the misdemeanors follow along with those.
Mr. Bowser. Your Honor, with regard to most of the counts, I think those are jury questions. I'm not going to really approach those, but I think adding the AWIM is a little bit overkill, particularly if you'll pardon the expression, particularly in light of the testimony. There was no evidence that he did anything to indicate. Yeah, he made verbal threats, allegedly, according to the testimony, all the time, and it never carried through. He threatened at one point to shoot her, but she never saw a gun, never got shot, et cetera, et cetera. They've got several counts of GBH. And Your Honor, again, because of the fact that we got very indefinite dates, it's a little bit hard to pinpoint what counts go with which testimony. But to add the 2 felonious assault charges when you've already got GBHs charged for those dates, given that FA is a lesser included of GBH, but I'll leave those to the circuit court. The only thing I'm going to object to, Your Honor, is the bind over on the AWIM.
The request to add count 7. Ms.
Your Honor, specifically, the reason we're adding that is the proofs came in, not only of the threats, but specifically when he was strangling her during I believe it was the 3rd incident she described with the bell. She felt herself about to pass out. She knew she was about to die, essentially. And he made statements, you're almost there, referencing that death that was surely coming. And the only reason he stopped is she was able to grab his genitalia and get him to back off. With that, we believe those elements have been met and the proof supported.
All right. The court has listened to all the testimony. I have to say that, quite frankly, I have to give Ms. Overy a great deal of credit because it was certainly tough for her to testify, but not because she wasn't telling the truth. It's because I believe that her testimony is extraordinarily credible, but just to try to keep a better term, the various forms of beating that she was taking in line and tried to remember what happened first. One of the remarkable things about her testimony and where she would have to back up is she focused and could tell and sort of wanted to get to those points where I think, quite frankly, she thought she wasn't going to make it. And then of each one of those events, she kind of begins heading toward that, and everything else surrounds it. It seems to make sense because everything in that is placed in context to those particular moments. With certainly these are questions of fact, but with reference to counts 1 and 2, people certainly have sustained a burden of showing that by virtue of her testimony of being choked on the 2 occasions, being choked, pushed down, smacked, and to the point where she's at the point of losing consciousness. The domestic violence aggravated, quite frankly, the 1-year misdemeanor, I don't need to address those, but those certainly the people have shown. The real issue from the defense standpoint, the court not addressing the misdemeanors, the court is going to add, let me just go to the easy ones, counts 8 and 9 of the felonious assaults, and quite frankly, there could be more of those felonious assaults added. I mean, counsel indicates he's unsure as to when those particular ones occurred. Pick your time and pick the weapon that he used at any given point in time. There are at least 2 of them. And be it the bar, where he hit her, the belt and other things also themselves could constitute the basis for felonious assault in the manner in which he used it. So I think that people have sustained their burden at minimum on just those two counts. With regard to count 7, the assault with intent to murder, I think in this case that is appropriate under these circumstances, in particular when one listens to exhibit, was it the voice, I think it was exhibit 2. No, I'm sorry, it may have been exhibit 1, the messages. Those are extremely disturbing and chilling because if you listen to Miss Owe on the first day, and I guess it's troublesome because she's just trying to protect those living things, inclusive of herself. She's just trying to protect those living things around her, her dog, her son, and all of those things. And she was talking about what she certainly felt, maybe something's not coming directly from the defendant's mouth. But then when you listen to the messages, it was clear what she felt. I don't even know how somebody threatens to kill somebody's child on the way to school, has the audacity at that point to pick a day when it's going to occur, and then says that he wants to then kill her. And for her to have certainly a reasonable belief, and quite frankly, my honest opinion is that if she had not gone to her mother's, it would have been a murder case. I don't have a doubt in my mind. At some point, he was going to do so much as to kill her. And I think his intent in some of these were to actually get to that point, particularly when he talks about her almost being there and sort of plotted out in his head and told her on the first incident exactly what order he was going to sort of extinguish the life of the 3 other living beings that were in that household, that being the dog, the child, and her. I think that given those threats he was making, those things that a reasonable belief is, and certainly could be, that he was intending on killing her. And I think when he talked about her almost being there, that's exactly what he was trying to do at that moment. It's just by her actions and quite frankly, probably the grace of God that she was able to escape and still continue to live beyond that. So I think that count is added appropriately. I would therefore bind the defendant over to stand trial. Well, before I bind over, I just want to say one other thing because I think it's an important part of the record. I gave the admonition to the defendant and to Mr. Goldstein regarding the defendant's conduct. And I did that because he was trying.
Now, the hearing shifts from testimony to charges. Watch how the prosecutor starts adding counts: assault with intent to murder, felonious assault, animal cruelty, destruction of property. They are stacking charges based on testimony already on the record. This is where the stakes shoot up. Defense calls the attempted murder count overkill, which is a bold strategy, considering what's been described, but the prosecutor pushes back hard, citing the strangulation incident and statements allegedly made by the defendant. This is where you see the legal tug of war. Which version sounds more believable to you?
Trying to stare her down. He was trying to use whatever nonverbal manner. Sir, you can shake your head at me all you want. I watched you this whole hearing. People don't think I'm watching. Keep shaking your head. Because see, you want to be a bully. You run into this bully, you'll lose. You are going to lose. trying to stare her down, intimidate her. Ms. Ori wasn't going to be intimidated. And quite frankly, and the reason I feel compelled to say this is because it's one of those rare cases, and I'm trying to think of another one, where as she was trying to recount what happened, having difficulty recounting what happened, the court's impression is he was receiving some joy from it. That watching her pain was somehow really what he wanted. And it was just amazing to me to watch that. And so I think it's important that, for my purposes and for purposes of the record, that the court point that out. I would also say that the people have sustained their burden. I would bind the defendant over on count 1, the 10-year felony on count 2, the also 10-year felony of assault with intent to do great bodily harm less than murder. And also then on count 7, the assault with intent to commit murder. And then on also counts 8 and 9, the added counts of felonious assault in each count. The other misdemeanor counts, those being count 3, 4, 5, 3, 4, 5, 6, 10, and 11 will follow along.
What a hearing. The judge's final ruling tells you everything you need to know about how seriously he took this case. He found the victim highly credible, added multiple felonies, including the attempted murder count, and then raised the bond to a jaw-dropping $5 million cash. That's not just a legal decision, that's a statement. It signals extreme concern for public safety and for the victim's future security. From start to finish, this case shows how emotional trauma, physical evidence, and behavioral patterns all work together to shape a court's interpretation of danger and intent. The judge didn't just bind this case over for trial, he practically sounded the alarm. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Follow along.
I apologize, Your Honor. The counts 3 and 4 are second offenses, as well as 5. So those
are felonies, yes, and I would bind the defendant over. I'm sorry, that is my fault, and I should have noticed that. I didn't read far down enough. So I would bind the defendant over on counts 3 and 4 and 5 also. Yes, thank you for catching that.
I apologize. People would have a bond motion given the testimony and added counts whenever the court is.
Yes. Mr. As to the arraignment, Mr.
Your Honor, we would waive presentation of the amended information. My client stands mute to all charges and asks of the not guilty.
Defendant having waived formal reading and presentation, standing mute, court will enter a not guilty plea as to all counts. Set pretrial in this matter for
December 18th at 1:30 with Judge Slay.
December 18th, 2025, 1:30 before Judge Slay. Sometimes things are just fortuitous. As to bond.
No comment as to that part, Your Honor. Your Honor, as to bond, people originally had requested $1 million. Magistrate said at 500,000 cash security, which we understand is high, but not quite high enough. And understanding magistrates have limited information. We're now at a point where we added felony counts, that's all to murder being the highest one. Given the testimonies, quite frankly, given the behavior of defendant in court today, our concern is still very high and has done nothing but grow our concerns regarding lethality at this point. So we would ask for that $1 million bond.
Your Honor, obviously he hasn't posted 500,000. It's a pretty substantial bond. We would ask that it be kept the same.
The court reviewing everything and having heard all the testimony, I'm going to be honest with you.